You're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury.
The defendant is in court today facing a terroristic threat charge, and he could be looking at anywhere from 2 to 10 years in prison if things go badly. The situation stems from a bitter custody dispute with his ex-wife, which already makes the case complicated before the hearing even begins. At the same time, he's also dealing with an ongoing civil custody battle. So what happens in this courtroom could impact far more than just a criminal charge. Judge Boyd begins a hearing by calmly reviewing the plea and the paperwork, just like any routine proceeding. But then she notices something in the protective order that immediately changes the atmosphere in the room. Her tone shifts, and you can see in real time that the situation has suddenly become much more serious. What do you think about Judge Boyd's courtroom style? Let me know in the comments. Let's dive into what happened.
Charles W. Booker for the accused.
Ronald Allen.
All right. Counsel, you received all discovery?
Yes, I did, Judge.
All right. You're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to the $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. Did you intend to give up those rights and enter into a plea in this case?
I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
I understand.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization? Did you understand?
I do.
Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea?
I do.
Defense?
Yes, that's true.
State?
Yes, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Charles Ireland or Mark Metley. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State tenders what has been marked States Exhibit 1 and all attachments.
Court will accept into evidence States Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right. Anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right. Any objections to the court reviewing the? Okay. All right. Yes.
And so, Judge, as you can see, essentially what primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. That letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that his GPS permit him to be monitored. That's fine if that's what the court desires, but he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or or Mark Medley is, that's new to me. But he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court, those are people that are listed under the protective order. And there's a third person, it appears, well, there are two other people. It appears to be either this is Gallegos, and then they have Ramirez, and Ramirez is listed as the amicus attorney.
Okay, Judge, those are not, those are other litigants that were also in the judge's notes. Ms. Gallegos is actually here in the court, and she's the custody lawyer for Mr. Allen.
I'm just saying, the judge's notes that you gave me, they have these people listed underneath protective order.
This is the moment where Judge Boyd starts to look visibly uneasy about the case. The fact that the defendant's former custody attorney appears on protective order is a huge red flag. You can tell right away that no one in the courtroom expected this, including the defense. The defendant suddenly looks nervous because this isn't some minor detail that can easily be brushed aside. If that attorney is actually protected from him, it makes the entire situation look far worse. It's hard to see how something like this would simply be a misunderstanding. How does a detail that's serious just show up in the judge's notes without anyone catching earlier? It really raises a question of why the defense didn't carefully review the paperwork before submitting it to the court. From the outside, it feels like a pretty careless mistake. From the judge's perspective, surprises like this are the last thing they want to deal with, especially when safety could be involved. This is exactly the point where Judge Boyd starts wondering if there are other details that haven't been fully explained yet. The whole pace of the courtroom seems to slow down the moment she notices Deal, you think this was just a simple paperwork mistake, or did Judge Boyd uncover something much bigger here?
No, Judge, I don't think that's accurate at all. I think that's being misread right now because...
I mean, that's the only way I can read it and the reason why I'm saying that's the only way I can read it is because it lists Medley, it says protective order, and then indented right underneath, it says M. Medley, which is the state has outside the agreement. They're asking for a no contact order with that person, with Charles Ireland. And then they have someone by the name of Gallegos and Ramirez.
Right.
And then right after it says that it has protective order, then right after it mentions those three names, then again, it says 2-year protective order granted as to, I believe that's the mother.
That's the mother's name. Yes, Mrs. Allen. Yes. But there is no protective order granted in that order regarding Mark Medley, regarding any of those people. The only one that has a protective order granted against is the mother of the child that we're talking about here. Ms. Gallegos is here and she hasn't asked for a protective order. And we know that the amicus doesn't have a protective order either.
Okay, so this is what I'm going to do. I've taken your plea, and if somebody can tender to the court whatever the orders are on the civil side, I'll review those, because those judges' notes that were handed to me appear that there's a no contact order. And I think you want to have those,
Right, exactly.
Know for sure whether it is or not, because otherwise you may be violating orders over there.
Absolutely, absolutely, black and white.
So what we're going to do is I've taken your plea. If you all are waiving PSI, I won't set it for a PSI. We'll just come back. When I'm back, I'm going to be gone the first week of September because I have to go to a judicial conference, have to keep up my educational courses. And then the second week, I have jury duty, and I can't have other people go to jury duty and sacrifice their work, but I'm not willing to do the same. So I have jury duty that week. So it'll have to be the third week in September, and that'll give everybody a chance, and perhaps a chance for you to speak with the state with regards to all the names that they have listed outside the agreement, because they have Medley listed as a no contact person too.
Well, and absolutely. And we understand that Mr. Medley called and asked for that kind of to be added to this order. That's my understanding from my discussions and my review of the state's file. But, I think the reason you see this line that says protective order plus merits is because that is what the topic of the entire, and what you're seeing here is actually the litigants that are, or the attorneys representing each of these litigants.
The best way to discover what that means is
Judge. Yes.
the judge.
I just have one request. We have services from my father September 5th. And I'm on the
Go to the
DPS.
services.
Yes, thank you. Thank you.
Yes.
Absolutely.
But here's the thing about going to those services and state, I've overstepped my bounds. Do you have any objections to his going to his father's services? All right. So what your attorney will need to do is I will print here a page with an order and I will do the style and you all need to write down your agreement.
Okay.
All right.
Absolutely. Thank you.
So you're welcome. So Ms. Ferguson, when can we bring this back? And when it come back, I will need specifically what the judge is saying on the civil side
Yes.
so that
absolutely.
this could a little bit be in harmony.
Absolutely, I agree.
All right, the 16th, is that enough time for you counsel to have everything ready?
Yes, of course, Judge. And I want you to know that the civil court is waiting for the outcome of this case
All right.
in order to make their orders. And that's one of the reasons Ms. Gallegos is here.
All right, Ms. Gallegos, if we can go off the record, Ms. Gallegos, if you'll come up.
If you enjoy watching courtroom hearings like this, be sure to like the video and subscribe to the channel. I'd also love to hear your thoughts in the comments. Let me know if there's anything you'd like me to improve or cover more often. Now, let's get back to hearing.
The first week of September, because I have to go to a judicial conference, have to keep up my educational courses. And then the second week, I have jury duty, and I can't have other people go to jury duty and sacrifice their work, but I'm not willing to do the same. So I have jury duty that week. So it'll have to be the third week in September, and that'll give everybody a chance and perhaps a chance for you to speak with the state with regards to all the names that they have listed outside the agreement, because they have Bentley listed as a no contact person too.
Well, and absolutely. And we understand that Mr. Medley called and asked for that kind of to be added to this order. That's my understanding from my discussions and my review of the state's file. But, you know, I think the reason you see this line that says protective order plus merits is because that is what the topic of the entire, and what you're seeing here is actually the litigants that are, or the attorneys representing each of these litigants.
The best way to discover what that means is
Judge. Yes.
the judge.
I just have one request. We have services from my father September 5th. And I'm on the
Go to the
DPS.
services.
Yes, thank you. Thank you.
Yes.
Absolutely.
But here's the thing about going to those services and state, I've overstepped my bounds. Do you have any objections to his going to his father's services? All right. So what your attorney will need to do is I will print here a page with an order and I will do the style and you all need to write down your agreement.
Okay.
All right.
Absolutely. Thank you.
So you're welcome. So Ms. Ferguson, when can we bring this back? And when it come back, I will need specifically what the judge is saying on the civil side
Yes.
so that
absolutely.
this could a little bit be in harmony.
Absolutely, I agree.
All right, the 16th, is that enough time for you counsel to have everything ready?
Yes, of course, Judge. And I want you to know that the civil court is waiting for the outcome of this case
All right.
in order to make their orders. And that's one of the reasons Ms. Gallegos is here.
All right, Ms. Gallegos, if we can go off the record, Ms. Gallegos, if you'll come up.
If you guys like watching court hearings like this, make sure to like and subscribe. And also let me know in the comments if there's anything you want me to improve on or cover more of. Let's get back into the hearing.
All right. Hello, how are you doing?
Yeah. Good, how are you?
Good seeing you.
Good to see you.
So anyway, it appears the documentation that I've received that has the judge's notes,
Mhm.
the way it's written, it appears that you're a part of the protective order. Bentley is a part of the protective order. So if the court can get clarification from the judge
Okay.
on that side about who is really included in the protective order and what they are doing with the visitation, that will be greatly appreciated.
Okay, we have a conference call next week, and then we will be looking to get it entered. We are hoping to obviously do it as soon as possible, and we will try to meet your deadline of the 16th. And I'll let the other attorneys know. If not, do we need to send an email to Ms. Ferguson?
No, I mean,
Okay.
so I'll just need that information before the 16th. So if you all can get the judge to, if you all want to, you can have the judge email me and
Okay.
say, this is who's a part of the protective order, or if there's a document, can you pass me that sheet of paper? Or if there's a document that tells me this is the part of protective order, because the way the judge's notes are written, it's so.
Okay.
Oh, you know what? I'm sorry. I need to add this.
So normally on the civil side, Mr. Medley is first because he's the petitioner. Margaret Gallegos, me, I represented the respondent, and then Anna Ramirez was the amicus.
Yeah, no,
and then it goes down.
The reason why I say that is because in the plea bargain agreement, even though it's outside their plea bargain agreement, Medley is mentioned. I'm sorry, can I have that printout one more time? So that's why I need clarification, because the way that's written in the judge's notes, as you can see, it has a title, protective order. Then it has a list of 3 people. Then underneath that list, then it comes back with a 2-year protective order. So it seems as though those are the people that he has a protective order against. So I would prefer that he know, I would prefer that I know, and probation knows.
So on here, it says 2-year protective order granted as to Mrs. Allen.
Yeah, but above it, it says protective order.
Okay.
So if you all will fill in the dates for him, please, and what you all have agreed on as far as his ability to go to his father's services. So that sheet of paper, if you can just put in the agreed times where he can travel for his father's services.
Okay, I'll do that now.
All right, and if you all will confirm that, and then we will come back. Norma, you said the 16th?
Yes, ma'am.
All right, so we'll come back on September 16th, and at that time, I will enter my order. And we're back on the record, Cindy. And counsel, it's the court's understanding you're waiving PSI and TAP evaluation?
I would.
All right, so thank you.
Thank you, Judge.
All right,
Thank you.
Thank you.
Thank you so much. I appreciate it.
Thank you, and thank you for dressing appropriately for.
So in the end, this guy actually walks out of court today without being sentenced, which honestly feels surprising considering the charge he's facing. You could tell that Judge Boyd wasn't comfortable moving forward until she gets clear answers from the other court involved. And in a situation like this, that's really the only responsible thing a judge can do. When a judge decides to pause a case like this, it usually means something serious has come up that needs to be sorted out first. A terroristic threat charge connected to a custody dispute is already a heavy situation. If that attorney was correctly listed in protective order, it could make things much worse for the defendant. The judge's reaction makes it seem like this might be more than just a small paperwork mistake. At the same time, it definitely feels like something that should have been double-checked long before the paperwork ever reached the judge. That part is honestly hard to understand. I'm definitely curious to see how this case develops once the court gets the clarification it needs. Let me know in the comments if you'd like to see a follow-up when more information comes out about this case. Thanks so much for watching. Don't forget to like and subscribe, and I'll see you in the next one.